Things are starting to get really interesting with U.S. immigration. Can Donald Trump give you a green? Hey guys, before you file for your spouse, hey guys, come on in, type in freedom now. This is the second live session that I'm having today. It's still Monday, and I'm back before you feeling more refreshed and in a quieter environment. So come on in and type in freedom now. We're going to go through some immigration issues, maybe a little bit of news here and there if you'd like to talk about news, but more importantly, to talk about your immigration questions. Say hello and type in freedom now, freedom now, freedom now. Thank you for being with me again tonight. For those of you who were with me yesterday, earlier today, let me know that you were watching earlier today during the lunch hour. Freedom now, freedom now. Things are so busy at the office, and there was a lot of distractions, a lot going on today. So I said, we've got to do this a second time today. Hey there, come on in. And if you're joining on Facebook, share this live session with your feed, okay? Share it with your feed so that other people will be able to get good information. Hey there, Avril, good to see you. Kwame, thank you for being with me. Our contact information, of course, is above. The office is closed now, of course, but the phone lines are open between 8 a.m. and 8 p.m. Eastern New York time. So reach out to us at 914-898-9488 or email us at info@McBean McBeanlaw.com to book an appointment with us. And Ashraf says, I'm new here. Welcome. Are we allowed to ask questions in the chat? Absolutely. That's what this is all about. I'm so glad you have this opportunity to join us tonight. Come on in, guys. Say freedom now, freedom now, freedom now. Thank you, Bochi. Good to see you. Thank you, Letitia. Thank you for being here. Any DACA updates? Lorena is asking. So, Lorena, I do not have any DACA updates aside from the fact that legislation has been reintroduced again. The Dream Act has been introduced again, and there was a lot of press around that last week, of course. We're going to try to hold Donald Trump to what he said several months ago about wanting to do something for Dreamers, or a few months ago for Dreamers. We'll see whether he really, really believes that. Now is really the opportunity that he has to really see, to show us what he's really thinking about this, right? So, but aside from that, the legislative update, I don't have anything further about DACA. Hey there, Nana. Thank you for being with me from Facebook. Thank you. Share this with your feed, guys, and give me some thumbs up. Good evening, Ebini. Good to see you. Thank you so much for being here. Rachel says that I have my marriage green card pending now for 11 months. Rachel, that sounds just about right. Honestly, it really does sound just about right now. Things have changed. Things are changing, and the process and times are longer now, right? Last year, we really enjoyed a lot of fast approvals. Some cases were approved in 2 months, 4 months, 6 months, but we have noticed a slowing down with marriage cases. The key with marriage cases, friends, during this time, is to really hone in on proving that you really have a bona fide marriage. You have your marital home. You have a way to show or prove that how your relationship developed over the years. You have brought things together, your joint bank account statements, you're filing taxes together potentially, you're doing things together, you're a unit, you're together, it's genuine, and you've got to tell that story. I'm going to revive an old course that I have out there. There's a free one too. There's actually a free a presentation that many people benefited from and downloaded, about how to tell your winning story to immigration. I think you guys will need that material again during this time to really tell the right love story, your journey to immigration, okay, in the way that makes sense for them. That's what that course, that free course, did for people. So we'll try to revive that for you guys, all right? Thank you. But be careful with your marriage cases. Um, if you filed an I-130 now for your spouse, how long is the process, especially if the spouse is outside of the U.S., outside of the country? Tamika is asking. So Tamika, it depends on which country your spouse is in and what's going on with the U.S. Embassy there and their backlog. The I-130 nowadays is taking longer than 12 months to be approved. For some people, it's a year and a half for the approval. It's like I said, it's just getting longer and longer, the wait time, even for immediate relatives of US citizens. That's what people are experiencing, and some of our clients as well. So once you pass through that, then you have to go through the visa center process and sit in their queue and wait for an embassy interview date. And that date is determined by the U.S. Embassy. So, Tamika, it depends on the country and it depends on these other factors that I've just mentioned, in addition to the fact that they're cutting staff and support at U.S. embassies across the country, the world, and so that will inevitably slow things down for these consular cases. So it's kind of hard to say how long anything's really going to take on the consular side these days. Hey there, thank you guys for being with me tonight. I'm so glad you came back in. Thank you so much for coming back with me tonight. Hey there, Samantha, Freedom Now. Freedom Now. What if you have TPS, temporary protected status, but also have a deportation order? So, Keith, I would want to know what country is your TPS connected to, but in any event, what we've been doing for our clients these days who have TPS and also deportation order is we assess the case to see if they have a pathway to a green card. And if they do have a pathway to a green card, well, we start the process for them. And for some of our clients, it's in phases, almost like baby steps, but immigration requires that for certain complicated problems. So once we've determined that maybe they're eligible for an I-130 through a relative, like a spouse, or even an adult U.S. citizen son or daughter, we start that process, file that I-130. Then we look to see what type, certainly from the beginning, we look to see what type of entry they have, what's on their record. For some people, believe it or not, in removal, some who are arriving aliens, it is possible for them to get their green card through USCIS despite the fact that they're in removal or have a removal order. But in any event, most other people are not considered as arriving aliens, and so they would have to go through a different process that would involve reopening their removal case as the next step. And then after reopening and terminating that removal case, then the next step is going to USCIS with a green card application. For some TPS holders, they might be able to still do prosecutorial discretion, although the administration doesn't really want to talk about that much and call it that. But for certain TPS holders, they are eligible to, through a settlement that our government was part of, they are able to get their removal case, get a prosecutorial discretion process approved by ICE that would allow them to reopen and terminate their old removal case. Those are individuals who had traveled on advanced parole and left the country and came back in, and they have a lawful entry on their record, and they fit the criteria of the settlement. Then ICE will help them, and we work on those cases still. We work on those cases. Anyway, Then after ICE says yes to them, then the court will sign off on it, or the BIA will sign off on it. So TPS to the green card is possible. We have a lot of testimonials on our website about TPS to a green card, but we evaluate each case very carefully for the right process. Can DACA holders travel to Florida? So DACA holders are still lawful in the United States. Okay, they're still lawful. And of course, they can travel to Florida. Florida is becoming a more oppressive state, where they are trying to crack down on immigration in a tougher way than any other state in the country. Florida is the only state in the country that has a law that allows that requires every county government to enter into an agreement with ICE, to cooperate with ICE, and turn folks over and report folks who pass through their jails to ICE. They're very aggressive there, and there are some other things that they have in play right now that they're trying to implement. I've talked about those details in detail in other videos, okay? All right, guys, come on in, type in freedom now, freedom now, freedom now. Good to see you guys. Share this guys, on with your feed on Facebook, okay? I'm gonna X out of Teams because I'm a little I don't want any distractions. So let's do that. Okay, so now let's keep going. Freedom now. Okay, Mike is asking, is there any chance for me to be approved for a green card if I have a 204C attached to my record? So now this 204C is a marriage fraud that is attached to his record somehow. So what we would do in your case, Mike, is we would get your records from immigration to determine whether they got it right, okay? When they labeled your file, so to speak, as 204C, or came to that determination, why did they do that? Did they get it right, or did they get it wrong? Is this something that we should fight? And we've been very successful in fighting some of these 204C allegations in cases where they were only allegations. But if it's a situation where this 204C was attached to your file correctly because you were part of a marriage fraud arrangement, well, we don't defend marriage fraud at all. But believe it or not, there are some ways that individuals under our law are able to still get through in certain circumstances. So for instance, with this 204C, for instance, if you had gotten a 2-year green card through from USCIS, and then you were trying to get your 10-year green card, and during that process they discovered that you got your green card through fraud. It was a fraudulent marriage, and then they deny your petition for the 10-year green card, and then they issued a notice to appear in immigration court to begin that removal process against you. Well, when that happened, you go into removal proceedings, and it's possible to ask for a waiver before the judge. And this is very, obviously I'm kind of oversimplifying it because it's not like that easy, the process, but it's possible for you to ask for this waiver before the judge in immigration court. But this is very limited to individuals who had received that 2-year green card to begin with, not the general person who had never gotten a green card because their case didn't even get that far. Immigration caught the marriage fraud way before it got to the point of issuing a green card. So that's one of the ways to get over it. There are blogs out there, a lot of information out there on the 204C bar. But if you'd like to go deeper and speak with us about your background, we'd be happy to speak with you to see if there's anything that we can do to assist you, okay? Thank you, guys. Thank you. Are you still subject to deportation if you have an approved I-140 EB3? So you have the approved petition, which is great. You're on track for a green card potentially, right? If the process hasn't stalled, has the process stalled because maybe you also have overstayed a visa and you're here unlawfully and you were told that you need a waiver in order to leave America for embassy process. If that's the case, well, it doesn't, the approved I-140 alone doesn't stop the government from detaining you or placing you in removal proceedings. It does offer you a limited argument to be made that you're trying to get things sorted out, you're trying to get back on track, but having the approved petition alone by itself doesn't stop the deportation process entirely. Okay, just it doesn't work that way. Arlene, it's good to see you. Thank you guys. Let's keep going. Type in freedom now, freedom now, freedom now. Okay, so Janet is asking if you're filing an I-601A waiver, will you also need the I-601 for the following 3 convictions: DUI, criminal trespass, and reckless conduct, not domestic. Janet, very specific. I like the way that you framed your question there. And so it sounds, I don't know, but are you working with an attorney to sort this out? Because I think that you're going to need some legal help here, and we're happy to help you sort this out. Because the thing is this, guys, when you file a 601A waiver, the 601A waiver takes care of your unlawful presence that will attach to you when you leave America because you've overstayed a visa, or you're here unlawfully and you have this unlawful presence on your record. And now if you were to leave, you would be barred for either 3 years or 10 years. It just depends on how much of this you have on your record. So it hits you once you leave America. So Janet, the 601A waiver would take care of that particular problem of the unlawful presence. But now if you say, okay, well, I'm going to file this I-601A to take care of that issue, and then I'm going to go to a U.S. embassy, because that's what that I-601A process will do. It's routing you to a U.S. embassy abroad to finish the process. When you get to that embassy and they look at your record and they make a determination that you have some other inadmissibility problems, and they recommend that you file the 601. If you're eligible for the 601, they will tell you to go file this waiver, but you'd have to stay there in your country of birth until the waiver is approved. I think that for a case like this one, we would certainly assess it very carefully, including every criminal conviction that is on your record, and see what are your chances of success with the waiver. Very important that you have that assessment done. All right, thank you. Hey there, Nyla. Okay, let's see. Let's keep going, guys. Luis, have you asked your question yet? I haven't. I'm just making my way down. Okay, thank you, guys. All right. Someone says that my father, Arlene, I'm sorry to hear this, that she said her father passed away in Jamaica, and I have travel documents from VAWA. Okay, great. I don't know if it's safe, however, to travel to Jamaica for the funeral at this time. So you have, Arlene, you have a pending VAWA case, and you have travel documents that would allow you to come back in to the United States and not abandon your VAWA case. The purpose of the travel document is just it's exactly for situations like this when there is an emergency that arise. Traveling, of course, leaving the United States when you do not have a green card or U.S. citizenship, of course, is risky. And I'm going to be like You're going to hear me say this a lot, okay? That it is risky because because this administration is so unpredictable these days. However, your advanced parole, your document will allow you to travel document will allow you to come back into the United States. Now, if you have a criminal record, that's an entirely different thing, right? If you, I would want to know, okay, well, what's on your record? And then if I see something or hear, you tell me what's on your record, and I think something is really a strong uh, record that would cause extra scrutiny when you're trying to come back to the United States, I would probably tell you not to leave, of course. But if you don't have a criminal record and you have your VAWA case, a good VAWA case pending, and you have your travel documents, then I think you would be fine to travel for your father's funeral. All right. Leonardo says that I'm traveling by car. I have an EAD through approved medical deferred action. Am I at risk? So you have medical deferred action. So the government will not deport you during this time, right? Deferred action. So you have deferred action. So I think you're okay. Oh, right. So this is a great question. Do I need to have a lawyer for a straightforward marriage green card case where I entered legally? So I still think that for marriage cases, individuals need a lawyer to help them with the case. Why? Because you know, the the ways of proving, and let me back up. You've got to prove that bona fide marriage. And so only you and your spouse know what your circumstances are, your background, and all of that. Um, but a lawyer can really put the case together, I think, in a convincing way and then also help to address any issues or problems that immigration could potentially send your way under this administration, like a request for evidence or trying to deny a case based on technicalities. It's going to be up to you, honestly. If you're a smart person, you're like, well, I handle paper all the time. I'm not intimidated by all of the paperwork that's involved in this process. I'm up to date on things. I saw that, oh yeah, today they put out the new, the January 20th version of the green card application and all of these other applications. Everything now is, the January 20th, 2025 edition. I'm up on things. Well, fine, you can go ahead and give it a try. But if you do encounter any problems, absolutely don't try to tackle those problems on your own. You can work with a lawyer to tackle those process for you. Yes, a child can file for you if the child is a U.S. citizen and over 21. Are there any updates on immigration court backlog? It's getting worse. That's the update, okay? It's getting worse because there are a lot of people getting off of TPS very soon, Venezuelans and Haitians, and so we're anticipating that a lot of those individuals will try to transition into asylum, which is, it's not an overnight process, though, to place those individuals in removal who are not already in removal coming off of the TPS program, because they're going to file an application. It's going to go to USCIS. They're going to wait for an interview date and all of that, and that takes forever. So the asylum backlog is going to become worse over time. It's not going to be an overnight flood. Right now, it's close to 4 million people who are in removal proceedings. Okay, almost 4 million people, and it's going to become worse very soon, as far as that backlog is concerned. All right, let's see. Shucks. Will there be any problems if an undocumented person files taxes this year? So Mercy is asking a very relevant question because in the news today, I also talked about the fact that the Department of Homeland Security is seeking data from the IRS related to undocumented immigrants seeking specifically their email addresses, home addresses, and phone numbers. And my understanding from reading an ABC article is that there is a list that DHS has that they are sharing with the IRS, and they're trying to get a hold of the data connected to those people on the list. I have no idea who's on this list. I don't know if it's a list involving the individuals who have criminal convictions that they know about, or people with a removal order, or just I don't know where they got this list from. In any event, filing your taxes, that's an individual decision to make. The government made a way for individuals without a social security number to do it. And it's called the ITIN process, right? Individual Taxpayer Identification Number, or if you have a social, they say file using your social. And now they're turning around with this list. So it's going to be at your own discretion. Follow the laws, of course. You're not going to catch me here on camera saying don't follow the law, because I'm smarter than that. But use your own discretion, follow the law, and follow your own conscience as well for a lot of things these days. But again, I don't have the clarity quite yet on this list, the names that they've shared with the IRS. And the IRS has pushed back saying we have privacy laws that we've got to adhere to. But my understanding from ABC News is that they're now working out the details of how to get around those privacy laws. So very concerning, of course. Can I travel with my advanced parole at this time? At your own risk, yes. I've already shared. Okay, at your own risk. Someone says that I have a VAWA case. I'm transgender woman and have my name gender change approved by the court. Do you think USCIS will honor it? I don't know if what they will honor with respect to the name change or the gender part of things. The name, yes, but as far as the gender, I'm not sure. This is all uncharted territory that we're all treading on, and all of the new forms under the Trump administration went into effect today. Everybody's got to use those new forms, and on those new forms they are very clear as far as saying male and female, and that's it, no other choices. So we're expecting that on the gender issue it's going to come up with respect to folks seeking asylum based on their claim of persecution or fear of persecution based on gender. It's also going to come up potentially for individuals who are maybe consular processing. Is it possible that, let's say for instance, an individual puts on, let's say the person was born as Jane Doe, female. Jane Doe, and that's what's on Jane Doe's birth certificate, Jane Doe, female. And then Jane Doe changes her sex later on in life and fills out a visa application. And on that visa application, she claims to be a man, right? And goes before this new embassy under this new culture that says, well, wait a minute, you've submitted to us this birth certificate in the name of Jane Doe, misrepresentation, you've misrepresented, you've lied, visa denied. Like, are those the things that are going to happen now? Are they going to be citing people for misrepresentation based on the fact that they've changed their sex? We don't know. Uncharted territory. We're watching this, but the name change part, they will be honoring that. Okay. Let's see. Thank you, Luis, for the super chat. And then let's see. Okay, here's the other one. The other super chat says from Silva says that I come with a visa. I'm over 21 and I'm single. My father is close to getting his green card. What is the best way for me to apply? Is it better to do EB3 and try to get a waiver, or wait 8 years until I apply under the F2B category through her father. So, or I don't know. So now, Silva, you're over 21, so an adult single person has a parent who will get a green card very soon. And that person you'll fall into the F2B category. You're here, you've overstayed, and this is the dilemma that a lot of adults overstay individuals face. It's going to be a long process to the green card. It's going to be a long process because under that F2B category, you could only go so far with it here in America. So let's say, for instance, you wait 6, 7, 8 years in this F2B category here in the United States, and your case is approved. Your priority date is current. Well, then you've got to jump into that next big step. If that waiver will be available, then it's available now. The 601A waiver is available. You file that. You're looking at, based on today's processing times, 3 to 4 years. So you tack that on to your father's, this case. Next thing you know, you're 10 years here waiting. It works, it's just lengthy, and then you'll have to leave and go back. Now, if you say, okay, well, I'm going to short circuit this process and I'm going to go in and do EB3, that might be a better option for you if you have a good EBE filing. You get your labor certification approved, and then the I-140, then you wait on that priority date. I don't know what they're up to now with the EB3. I haven't looked at the visa bulletin recently in that particular category, but you're expecting to, I think, hold on, let's see, let's just pull up the visa bulletin very quickly here, still in March, okay, to see where things are at right now. But just also keep in mind that if you do the EB3 process, you will still need that waiver, which is so annoying. So depending on what country you're from, I should say, country you were born in, you're not facing a very lengthy time with the EB3, December 2022 right now. So it's just a couple of years based on tonight's processing, but based on where things are at with the March visa bulletin, which could retrogress, go back, or it can move very slowly. Okay, so if you have the opportunity for the EB3, absolutely start it. Once your father gets a green card, start that too. You could have multiple processes going at the same time. Just get on track. But you can reach out to us if you'd like to talk more with your employer or prospective employer about the EB3 process. So the app that I use, guys, for this, for my live sessions, I use Ecamm. Okay, that's what I use. I've been using it for years. Ecamm. So it's when I jump over into Super Chat, and then I go back over into the regular chat. It starts me at the very top of the questions here in the regular chat, and so that's why it's so annoying. Try to get back in. Okay, don't let me start the banning. I don't want to ban anyone today. I don't think we had to ban anyone. Let's go back up here. Thank you, Jacqueline. Thank you. Let's see. Where did I leave off at? Oh, there it is. I think it was question, and then okay, here's an interesting question. My asylum case was dismissed, stating that my kid should file for me. She has a green card. She filed for citizenship, and she's waiting for her interview. Am I at risk or out of status and should be worried? Well, it sounds to me like you are out of status. You have no status at this time. You had an asylum case that was pending in court, right? Pending, and it was dismissed in court, so you're no longer in removal, which is amazing. You've dodged a major bullet. That's great. But now you just got to wait until your daughter gets her citizenship. And once she gets that, she could file for you. And depending on how you enter the United States, you might even be eligible to adjust your status. So just hang in there. You're on track. Don't worry too much, okay? You're not on the radar. I need to explain to people what the radar is, right? There's the radar and then there's the radar. Now I'm really curious about what's on that IRS, that list that was submitted to the IRS, the names. Okay. So DUI is a problem for this administration. Okay, if you have a DUI or any criminal record, you should absolutely speak with us before you proceed with immigration. Okay. Freedom Now, Marilyn, good to see you. I hope you guys are feeling okay tonight. I know that, there's a lot going on, but we're in this together, okay? Type in Freedom Now. Okay, let's see. I have an approved I-130. If you're enjoying tonight's session, just let me know in the comments that you're enjoying tonight's session, okay? And us spending this time together on this Monday night. I have an I-130 approved with a I-601A waiver pending since 2023. Okay, I'm in the United States. I've been here for 30 years with an administratively closed C8 case with a work permit. What should I do? So you have an asylum case, I believe, right? The C8 category. You're in removal. It sounds that way, right? You say that you have an administratively closed asylum case and you have a work permit connected to that pending asylum application and removal. And now you have the 601A. I think you're going to need to come see us. Okay, you could come in person, of course, or have a meeting with us so that we can sort this out for you to make sure you're following the correct procedures, okay, and that that you could actually get a green card through this process. It sounds like you're on track, though. All right. Hey there, Victoria. Good to see you. Good to see you. Freedom Now. I don't know. When I was a little girl, I was so obsessed with the name Victoria. It's like my dream name, Victoria. Such a great name. Good to see you. Let's see. If your parents were convicted of a crime, will that be a problem to get your green card? Susie is asking. So Susie, if you have, if that parent has a disqualifying offense that disqualifies him or her from petitioning for you from submitting that I-130, like for instance, they have a sex offense that they've been convicted of, but still, even if that's the case, then you should still work with a lawyer to assess it, because for some people there's ways of arguing around this Adam Walsh Act. So we don't always say to people, oh, just because you have a sex offense, you're disqualified. No, we actually take a real thoughtful look at it to see if there's a way that we can make an argument around that Adam Walsh law. So that's what really comes to mind. That's the criminal conviction that really matters when it comes on to being a petitioner. Okay, let's see. Kwame says, if you have one more year to go to file for your citizenship and now your spouse has requested a divorce, what are you supposed to do? Should you continue your application? So Kwame, are you trying, it sounds to me like that person that person is trying to do early naturalization based on marriage. And if that's the case, I would say don't do it. Just wait for the 5 years as a resident and then apply for naturalization at that time. I would just wait because with this threat of divorce happening here, it's going to be a problem for the early naturalization process, okay? Okay, so now I've jumped back over into Super Chat, so I've lost my place with the regular chat. Now let's see. I've got to get that looked at. If I could stop moving, right, and spend 15 minutes on that setting, I could figure it out. But I move around a lot. Um, uh, Let's see. I'm going to get back to Nestor. Nestor, I'll get to you momentarily. I have to kind of think that one through for a second. Mandy says, Haiti TPS holder who came on parole, okay, can she get a work visa? She's a CNA or asylum. She's been here for 2 years. Been here for 2 years, and this person is on TPS, which is most likely going to go away this coming summer. Can she get a work visa? The work visa might be a bit of a challenge. It might be a bit of a challenge. It really depends on after the TPS. Once TPS goes away, folks will obviously go out of status. And so I'm not going to say on this forum that, oh, just go for asylum, first of all. Go for asylum, go for asylum. No, you would not hear me ever say that to anyone. As a matter of fact, I always say don't look at asylum as the default and just go jump into it, because you jump into it, well, many years down the road, after they interview you, they will place you in removal if they're not convinced that you have a story. And then that will really tie things up even worse for you with immigration. So avoid that. I don't know if asylum is going to work, if this person is eligible for asylum, under what basis. Just because she's from Haiti doesn't mean it has to be she's eligible for asylum. A lot of Haitians are denied asylum because they really don't have a case. So we would look at that if there is any kind of case. As far as the work visa is concerned, that's a bit trickier because it's a timing issue. As I was saying earlier, if she goes once she goes out of status, there's going to be a problem there for the ability to later adjust status through the work visa, the employment-based green card pathway, which I think that's what you're asking. I'm not sure if you're asking about like a temporary work visa. That's a little trickier. So I don't know about the work visa, whether that would actually really work for her. And then asylum has to be assessed before she thinks about applying for asylum, okay? Let's see if I could go back up here to this one. Hello from Denver. I am on DACA. I'm trying to get an FAA drone license, and it says a U.S. citizen or legal permanent resident. Okay, so that you don't have your green card quite yet. Okay, so be careful with these applications, guys, because if you down the road, when one becomes eligible for a green card and they look at the applications for a green card, and maybe if they get the green card and then apply for citizenship, they face some similar questions. But the issue is, have you ever claimed to be a U.S. citizen at any time for any reason on any application, really? And it would include things like that. So be very careful with these types of applications. Okay. Let's see. Larry says that my wife and I have an I-130 and an I-130A. I'm in Baltimore. She's in Angola. Our case is being processed in the Texas Service Center. Our case is being processed in the Texas Service Center since December 2023. Any advice? Okay, so you might, I don't know if you heard me say earlier, Larry, that the I-130s have slowed down, okay? Um, Even for US citizen petitioners, it has slowed down and it will be a little, I think that it's going to be moving at a glacial pace for a good while under this administration. So these I-130s are taking longer than a year. Not to worry, although I don't know also whether you're a green card holder, Larry, or a US citizen. I'm not sure what your status is. If you're a green card holder, it will take longer, a few years, maybe 3 years, I think. Let's look at the visa bulletin for the, just up real quickly, the F2A, they're up to January 2022 right now. Okay, so there is a delay in this F2A category. And then there's the embassy process that your wife will have to go through in Africa. This administration, they are coming out soon with travel bans or suspension of entry for certain countries, which will be challenged, of course, but they're working on that, developing that list right now and the rationale to suspend entry for certain countries based on security reasons. And then they're also looking to really cripple the embassy process globally. They don't like, they really, 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 really on a deep level don't like the African immigrants flowing in from Africa. I just can't say it in any other way because the Trump has indicated that in the past, okay, a number of times. So I don't know what they're thinking right now with respect to African countries or what they're planning on, but I do know, just generally speaking, embassies across the world will face a massive slowdown. So I think that that will impact your case. If, however, Larry, there is a way to expedite your wife's case, your wife's processing, we will be looking for that. We will be looking to see if there are any urgent issues happening on her side or your side, any humanitarian issues that are happening on her side, to see if we could get her case expedited. Now, there's a process for expediting even the I-130 through the immediate relative process, and there's also a process of expediting things at the National Visa Center so that she can get a faster date at the U.S. Embassy for her interview. So those are the things that could help her case down the road, but it really all depends on what's going on, okay? All right, guys. Let's see. Freedom now, freedom now, freedom now. Thank you, guys. Give me some hearts, give me some likes as you're joining on McBean Immigration TV on YouTube. All right, let's see. I'm going to jump back over here and make my way down. Okay, let's see. Okay, this Renee's asking a very good question. Is it normal for the petitioner of an I-130 to get a biometrics appointment? It's not normal, okay, for the petitioner to get it. I think something must have come up with the petitioner's name or yes, and so now they would like to do an FBI background report. They want to drill down a little bit further. I've seen this come up in my experience with um, with sometimes when the petitioner has a criminal record that could disqualify him or her from petitioning for you, like a problem under the Adam Walsh Act involving a sex offense of some sort. That's how I've seen it come up. You can reach out to us, absolutely reach out to us to talk further one-on-one about this, maybe you and your spouse. But it's not really that, it's not normal it doesn't happen very frequently that the petitioner would get a biometrics notice as well. There's no way you can file for a sister. So the sibling process is still there. U.S. citizens can file for their siblings, okay? Let's go down a little bit. Um, Okay, so Bola says that I'm a citizen. My husband, before we married, filed an asylum case, which is still pending. Can we file adjustment of status with his pending asylum case? Bola, we've done it for folks in the past. If they have a record showing how they entered into the United States, that they were inspected, and they were lawfully admitted into the United States or paroled in, there is a way for them to submit their adjustment of status application, even with an asylum case that is pending and is already filed. If you'd like to go deeper or to have us work on your marriage case, contact us. We'd be happy to speak with you and work with you. Um, let's see. Let's keep going. Are green card holders safe for travel under 6 months and safe when they come back in? Yes, they are. For the most part, most green card holders can travel and not stay out longer than the 6 months. That's the point that I keep telling people not to go beyond. And but there is a travel advisory still about green card holders who have a criminal who I'm sorry, green card holders who are in removal that they should not travel internationally, including those who had a 2-year green card and then you had your 10-year green card application was denied and you had gotten permission to travel, and you're in removal proceedings. That those individuals should not travel either. Green card holders who have I would say a crime involving moral turpitude on conviction on their record also should consider think twice before traveling. Green card holders with serious criminal records should absolutely think twice before traveling as well. All right. Type in freedom now, guys. Let's see if you're enjoying tonight's show. So many questions. So many questions. I was married before, and my case was denied based on lack of evidence. I got divorced, and I married a new wife. We have a daughter together, and everything is in our name together. Should I be concerned? Tio is asking. So Tio, you know, if with the previous denial, my first recommendation obviously is to work with a lawyer on this case. We would get your records from immigration and see what happened with the first case, because when you file a new case, their immigration still has that record and they often refer back to it to say, what happened here? And you don't want them to draw wrong conclusions about things based on the fact that you have a denied marriage case for lack of evidence. And guys, I will tell you this, even though they say lack of evidence, it doesn't mean that they're not thinking that you've committed marriage fraud, because sometimes they are thinking that it was marriage fraud when they say things like lack of evidence. And under this new administration, they definitely take that position. Some of you will see that over the next 4 years. So before filing a new case, absolutely make sure that your first case is explained to a lawyer privately, so that the lawyer can tell you, or we can tell you, what we're really thinking and how to approach the second filing strategically. Now, strategically, some people, based on USCIS's practice, what they would do for some people in this situation is, after you file your new case, they would issue a notice of intent to deny. Just depends on what's on the record, or a request for evidence, and of course an interview notice. They would like to have you come in and explain some things. And so those are the things that happens for some people who have a denied case based on lack of evidence or based on marriage fraud allegations. But we have a lot of good stories, success stories on our website about scenarios just like this of people who've been denied, and we were able to help them get their green card. All right. All right. Awesome. Good to see you guys. Good to see you, Rashida. Good to see you. Let's see. Let's go to, let's see. Oh, let's go down a little bit. Shucks. Um, does a person have to wait for the I-130 to be approved before filing for adjustment of status if the spouse is in the U.S.? So the question is, in a marriage case, in a marriage case, when there is an approved, do you have to wait for the I-130 to be approved before filing for adjustment of status? So for some people, they do not have to wait. They could file both the I-130 and an adjustment of status application together, which is recommended if the person is eligible for adjustment of status and they're not in removal. There's no hurdles in their way that says they can't do it that way. So for those who are eligible to do it both together, it's advisable to do it together. For some other people, they have to absolutely break it up. It just depends on the facts and the background. Okay, there's my timer. I was looking for it. I'm almost at the 1 hour mark, guys. So I'm gonna be jumping off very, very soon. Good to see you, super 29 super. All right. I would like to apply for my citizenship. Rashida says I've reached my 3 years. Rashida, you can get an appointment with us for us to take a look at that issue and to see if you're eligible for citizenship, and we'd be happy to help you with that. So let's go back over here. I married 14 years ago, I guess. I've passed my citizenship interview since September, and now it's March, and I still have not received my swearing-in date, and I don't have a problem with the law. What's up? What could possibly be going on? So you had your interview in September. Yeah, I think something could be going on, honestly, because with citizenship, particularly those who were going through the process last year, things were so fast because it was election year. And just even when it's not an election year, when a person interviews for the citizen during the naturalization process and they've everything's good and they've passed it, it usually happens very quickly as far as being sworn in, like really fast. For many people, it's the next month that they're sworn in. So you can have us take a look at what could be going on. Okay, we're going to ask you some questions about your green card process. As you've mentioned here, you don't have a problem with the law, but I'm curious to know what they potentially are looking at. And I could, maybe have some indication once I ask you some thoughtful questions one-on-one. But generally, so it's usually much faster than this as far as being sworn in, okay? I was I was charged with disorderly conduct connected to domestic violence. Will I be able to get a green card in the future, or can I face deportation? Um, I think you might still be able to get a green card. I'm not sure Okay, we have to learn a little bit more about this. This was only disorderly conduct, although maybe the record obviously would show maybe there was a fight or an argument or something going on with a domestic partner. But we'll take a look at it at your criminal record, and we will be able to tell you what the immigration consequences are for that record. So if you haven't, have, if you think that you have a pathway to a green card, you could come and speak to us, and we'll confirm that, and we'll take a look at your record to see whether you really do have a way forward. Um, if the military parole is rejected, can it be appealed? It's discretionary, by the way. The government, this is completely 100% discretionary, the military parole in place, okay? Is it better to wait until we have kids before I apply again? Wait until you have kids so that I will have more leverage. Tips for applying. Let's talk thoughtfully about your background, and why are you thinking if it is rejected? What makes you so concerned about it possibly being rejected or denied? But again, it's discretionary. Have a meeting with us so that we could go a little deeper to see if you have any other way forward in the event the military parole in place is denied. Guys, this was wonderful. 1 hour together tonight. I'm going to sign off now. Today we had a live session in the middle of the day, but I was so distracted by a lot of things happening at our office that I said, let's do a second one tonight. Thank you so much for coming back with me. You guys are the best. Don't forget to reach out to us. Reach out to us, guys. Reach out to us. You have our contact details. Also, go to McBeanlaw.com/free, FREE, to download some of our free materials, including our Know Your Rights materials and some other free downloads that we have on our website. Also, don't forget to subscribe to our weekly newsletters. We have some terrific information that we share to our subscribers 4 times a week via email. Get on the inside. Tomorrow we have a Q&A going out. Yesterday we had um, our success story, which I'll share with you guys very soon by video as well. And then, today we had a great 601 waiver approved. We were so happy for our client. I kind of wish I knew the timeline on it. I didn't really look at it carefully. We had a great 601 waiver story approval coming today. We'll tell the story to you guys very soon as well. Don't give up hope, guys. When is the next live session? Singa, I'm planning. So if you haven't noticed yet, I have a little strategy. I have a little method to the way that I do things. And so my strategy, my method is this, that typically I have one YouTube live on Mondays at 1 o'clock. And then I have a social media live either on Tuesdays or Wednesday nights. I do an evening live session to social media, TikTok, Facebook, and Instagram. Facebook is on tonight as well too. So that's going to be Wednesday. Most likely it's going to be Wednesday. When news breaks, I come out and I just talk with you as it breaks. So follow me on TikTok, Instagram, and Facebook for staying completely in the loop, and particularly on Tuesdays and Wednesday nights when I'm able to go live, usually after 8 p.m. Eastern time, okay? Between 8 and like 10 p.m. I go live. Guys, thanks so much. It was great being with you tonight. You are the best. I will see you in the next one. Bye-bye.